Thank you, Chair Ray and members of the House General Government Committee for the opportunity to provide opponent testimony to Senate Bill 293. My name is Collin Marozzi, and I serve as the Advocacy Director of the ACLU of Ohio. In the November 2025 general election, the Medina County Board of Elections received and counted 57 ballots during the 4-day post-election day window. The Wadsworth City Council Ward 4 race was decided by 9 votes. The Wadsworth Ward 3 election was decided by 5 votes. The Liverpool Township Police levy lost by a 9-vote margin. In Morrow County, 21 ballots were accepted during the 4-day post-election day window. The Harmony Township Fire levy won by 10 votes. 45 ballots were received and counted during this period in Licking County. 3 candidates for Licking Township trustee were separated by 14 votes. In Perry County, 8 ballots were received and counted. The Village of Junction City's police levy was decided by 2 votes. In Stark County, 275 ballots were received and counted. The City of Alliance Ward 3 race was decided by 48 votes. The Minerva Local School Board election was decided by 17 votes. By stating these numbers, I hope to convince the members of this committee how consequential of a change Senate Bill 293 is. Lawful voters casting lawful ballots by a lawful method should not be punished for something completely out of their control, mail delivery times. Over 7,000 ballots were received and counted over the 4-day post-election day window in November of 2025, and over 4,000 ballots were for the May 2025 primary. These voters are by definition the most knowledgeable, engaged, and reliable voters in the state, and they still would have had their ballots thrown out should Senate Bill 293 become law. Senate Bill 293 does nothing to make our elections more secure. It does nothing to give voters more clarity on the ballot receipt deadline. It does not bring us into compliance with any federal law. All Senate Bill 293 does is force our dedicated local elections officials to throw otherwise valid ballots in the trash can. If Ohio was serious about making absentee balloting more timely, we should increase the number of drop boxes, we should make absentee ballot requests available online, we should allow for a permanent absentee ballot list, and more. There are more and better answers to this question than Senate Bill 293. Thank you, and I'm happy to answer any questions both on the proposed bill but also the amendment.
Thank you very much.
Thank you.
Any questions for the witness? Representative Russo?
Thank you to the chairwoman. Thank you for being here. And I appreciate those statistics at the beginning because I think it's an important reminder for us that elections are for the people and what people choose. They're not for candidates. And so I'm far more concerned about a voter's vote not being counted than I am about a candidate being unsure on election night whether or not they won. I want to go back to the whole premise of this as being based on a Fifth Circuit court decision and a case that is that is being reviewed currently in front of the U.S. Supreme Court. We are preemptively changing state law and our process that has worked well, that voters like. We are preemptively changing because of what might happen, not what has happened or will happen. And I seem to recall many folks from the majority party and many, including the Secretary of State, saying that the Fed should not be involved in our election process and telling us how to do things because states set how elections are administered. Can you talk about the process of that U.S. Supreme Court case? It has not been decided. It hasn't even been heard as far as I can tell. And so we are doing this exclusively for something that has not happened but might happen.
Well, through the chair and to the representative, you're absolutely correct. The Fifth Circuit case, RNC versus Wetzel, first of all, as a Fifth Circuit case, it doesn't apply to Ohio. Ohio's in the Sixth Circuit. But if you look at the actual question on the merits, I think the decision of the Fifth Circuit could generously be described as novel. The U.S. Constitution allows for election law regulations to be set by the states, absent clear legislative preemption by Congress. Now, I know you asked this question to the Secretary earlier. I had to step out, so I wasn't able to hear the answer, but I will answer. There is zero federal law that says states are prohibited from accepting ballots post-election day. That does not exist. What the Fifth Circuit decided was an amalgamation of federal statutes that have been cobbled together to present this notion of a single election day. And even when you look at the decision in the Fifth Circuit, it's mostly relying upon a case called Foster v. Love, which is a case out of Louisiana in the 1990s. Foster v. Love was a case challenging Louisiana's election system of essentially having an open primary in October, and if a candidate emerged from that open primary with a majority, there is not an election in November on that election day. That is the ruling where the court struck that down, saying no, Louisiana would still have to have a general election because these three federal statutes say this is the day of the election. That is the case that the Fifth Circuit relied on to create this new requirement out of thin air, frankly. And even their interpretation of Foster v. Love is incorrect because in that same opinion, the Supreme Court blessed Georgia's runoff model, which allows for Senate elections to be had post-election day should a winner not receive a majority. So I say that it's a novel interpretation of federal law because we've never seen a case decided like this previously. It would invalidate election law in 16 states without a clear mandate from Congress, which they have the authority and the will to have. You know, it's not as if Congress has shirked from its responsibility to pass concrete election deadlines in the past. The NVRA requires states to have a voter registration deadline no more than 30 days before Election Day. And there are, if you look at UACAVA, the UACAVA Act, that sets the date for 45 days before Election Day when absentee ballots can be sent. So Congress can create hard and fast deadlines where they want to. They didn't in this respect. And so I think that proponents of that litigation have a tall task ahead of them at the Supreme Court. I won't guess how that's going to shake out, but when you look at the actual text of the federal statute, there's no bright line that states are prohibited from accepting ballots after Election Day.
Are there any other questions for the witness? Representative McClay?
Thank you, Chair. Thank you, Mr. Marozzi, for coming in. Appreciate the stats that you brought here on the last election. And those were operating under the what we have on the books today, our legal framework that we have on today. So we're legally cast, legally counted, affected. And I would argue that if we were, if we decide to change that, people certainly can adjust and accommodate based on what the changes to the law are. I think what would be more, impactful in terms of statistics would be the 34 states that have this law on the books today. Do you have any stats from those states as to the number of ballots that come in after Election Day that would be, thus, not counted?
Through the chair to the representative, unfortunately, I do not have those stats. I do have a couple stats, though. And when I was looking at the National Conference of State Legislators website to see which states don't accept ballots post-election day, I found a few, and I looked for population parity for Ohio to kind of do an apples-to-apples comparison, and I looked at Georgia, North Carolina, and Illinois. Illinois is more populous. Georgia and North Carolina are the two states immediately following Ohio. Georgia and North Carolina both prohibit absentee ballots from being accepted after Election Day. However, when you look at their early voting in-person polling location counts, they dwarf Ohio's. Ohio has 88 early voting polling locations, one per county. It's a well-known rule. Georgia has 366. North Carolina has 612. So I think when states do move to do things like this, where you are eliminating that 4-day grace period, even though, and keep in mind, for these ballots in the 4-day grace period to even be counted, they have to be postmarked the day before Election Day. So these voters have technically cast their ballot before Election Day. So if those are still removed, we need to open up, I would say we should open up additional options, more voting locations, more drop boxes, to allow folks who want that certainty, which I grant when you put your absentee ballot in the mail, There is a degree of uncertainty with that, and that will never be solved. However, that 4-day grace period allows for delays to not cost people their ballot. And it doesn't cost boards of elections any time either, because in statute, Ohio Board of Elections are unable to begin certifying election results until the 5th day after Election Day. So they still have this window before they're even allowed to start declaring officially the winner. It seems to me like this is a 4-day window that Ohio is putting to good use. Postmarked ballots, ballots cast before Election Day, should be counted if there's a slight delay in the Postal Service. People, when I talk to voters, I'm sorry, and I'll finish. When I talk to voters, the deadline people think is when they put it in the mail. Well, I cast my ballot before Election Day. I put it in my mailbox 3 days before Election Day. In their minds, it should count because they voted before Election Day. I'm sorry, I don't have any statistics on what you asked for, Representative, but I'd be happy to provide them to your office.
Representative Oslover.
Thank you, Madam Chair. Out of curiosity, what was the vote in the circuit court?
In the Fifth Circuit, Representative, it was 2-1.
2-1. And do we know who pointed which?
So they were, I believe, through the chair to the representative, the 2 judges that had the controlling opinion were appointed by President Donald Trump. I'm not sure who the 3rd one is. However, if I could elaborate, if we also look at the 7th Circuit in Illinois, there's a current case being litigated, Boast v. Illinois State Board of Elections, in which this exact same issue is being litigated, Illinois' 14-day post-election day deadline. And in that case, Judge John Kness, also a Trump appointee, ruled that Illinois' 14-day deadline is, quote, facially compatible with federal statute.
Thank you.
Thank you.
Representative Plummer.
Thanks, Chair. There's 3 states you're talking about with multiple early voting locations. You probably don't have the data on it. We all want a better turnout, right? But we all strive for that. Was that better turnout there, or could you find that out for us compared to Ohio? I mean, it's not apples to apples, obviously, but if you have more opportunity, more locations to vote early, even though we probably wouldn't have the money to pay for it, like the legal women voters said, but
Through the chair to the representative, I am not sure, but I would be very happy to provide that to you. Thank you.
Any other? Representative Sonnenberg.
Thank you, Chair. Thank you for the testimony today. If this bill were to pass, it seems like what you're suggesting in your last paragraph of your testimony here is that, I guess, a trade-off would be that we should be like more of those 34 states that do not allow absentee ballots after to be counted if they're not received by Election Day, in terms of making absentee ballot requests available online, allowing for a permanent list, increasing the number of drop boxes. Do you think that that is a fair trade-off, if you will?
Through the chair to the representative, I guess I would first say that I am not concerned whatsoever of doing something that 34 other states do. If Ohio is intent on calling itself the gold standard, that implies that we need to do some things that other states don't do. So I would encourage the state to reverse course on this and maintain that 4-day window. However, should there need to be a tick for tat or a kind of evening of the ledger, I would think that the ideas presented in this testimony are the least that this state could do. I think that if we are going to be, especially including the amendment, if we are going to be routing voter registration almost exclusively through our our Bureau of Motor Vehicles, automatic voter registration is a no-brainer. If you are already required to go and obtain a photo ID, driver's license, state ID, then it should be also that your Board of Elections automatically registrates you until or unless you opt affirmatively out of that. Also, I think if we're going to be talking about how our local BMVs are going to be kind of the hub of registration, voter registration, then we need to, as a state, shore up our BMV system. I'm sure we all are aware that our deputy registrars are actually private businesses. They are not state-owned enterprises. They do state functions, but private businesses own and operate our BMVs. That means that some counties are having a closure of BMV offices around their area. Some counties down in Appalachia are already down to one, perhaps none, operating BMVs. So when we're talking about our election system, we can have a holistic approach to find solutions. At a minimum, I think these are easy lifts included in my testimony.
Yes. Thank you, Chair. One follow-up. Would you say that if we were to pass Senate Bill 293 and we don't do some of the things you implement, we'd be probably, in terms of access, in the bottom few states?
Through the chair to the representative, it would be another data point in a very troubling trend of sacrificing voter access and integrity in the confidence of an election, both from preventing fraud, but encouraging participation, encouraging access. Ohio has been on a steady drip downward in access granting. It has skyrocketed in preventing and complicating the process for voters to be able to actually participate. If Senate Bill 293 passes without, frankly, period, if Senate Bill 293 passes minus major amendments, then that's just another continuation of the very troubling trend of making it harder for Ohioans to vote and throwing ballots out for no fault of the voter.
Thank you. Anyone else? Thank you very much for coming to committee
you.
today.